The next petition is PE1370 by Dr Jim Swire, Professor Robert Black QC, Mr Robert Forrester, Father Patrick Keegans and Mr Iain McKie on behalf of Justice for Megrahi, seeking justice for Megrahi. Can I seek members' views on how, in fact, Christine's here. Christine, would you like to address the committee and then we can go to questions?
Thank you very much, Convener. And can I commend the stamina of this committee for its late sittings? Don't know if I've got it. I'd like to refer, first of all, if I may, Convener, to the letter and the reply from the Scottish Government in particular at numbered paragraph 2, where it says the Government's response to these questions is as follows. And if I may say, it says a second appeal, 3 lines down, a second appeal following a referral from the Scottish Criminal Cases Review Commission was abandoned by Mr Megrahi. The conduct of his defence during his trial and his appeals, including his decision not to give evidence at trial and the decision to ban the second appeal, was entirely a matter for Mr Megrahi and his legal advisers, and goes on to say that the petition is inviting the Government to do something which falls properly within the criminal justice system, that there are roots within that, and accordingly that should be an end of the matter. Now, if I may, and I'm quite ready to challenge my own government, that is not the fact. The fact is that, first of all, we know why Mr Megrahi abandoned this appeal, because Maggie Scott QC told the court why he did it. And I'll paraphrase, but the words to the effect were that her client believed, Mr Megrahi believed, it would assist with his applications, plural, which meant for prisoner transfer and compassionate release. Now, prisoner transfer, of course, did require abandonment of appeal. Compassionate release did not. Now, we can struggle over why he abandoned them, who said whom to what, but that is a fact. He believed that. So these are very extraordinary circumstances. Then one must challenge whether or not there is a route within the criminal justice system now open to Mr Megrahi other than a public inquiry. And if you'll just bear with me a little, I'm going to refer in a rather, I hope, lawyerly way to legislation that was brought in recently, which comes under the, to find the name of the Act again, which is the, in brief, it was in my hand, the recent legislation that was brought in to deal with the case of the people who were not represented when they were being charged, and I'll get the name of it. It's, here we go, bear with me, I'll just give my submission, then I'll tell you the Act. In that particular Act, under Section 7, it's the Criminal Procedure, here we go, Criminal Procedure Legal Assistant Detention Appeals Scotland Act 2010. If you recall, we dealt with that all in one day, Stage 1 through to Stage 3. But there was a section in there which I referred to, and I tried to amend by having deleted from the Act, because it did something really radical to the Scottish Criminal Cases Review Commission, which, you know, was an independent body set up in 1999 to deal with miscarriages of justice, independent of the courts, independent of us, thankfully. Now, that particular section did something very strange. It brought in a particular section which says, and this is Section 732, in determining, this is for the Criminal Cases Review Commission, in determining whether or not it is in the interest of justice that a reference should be made, the Commission must have regard to the need for finality and certainty in the determination of criminal proceedings. So, for the Criminal Cases Review Commission, an independent body, to say there may have been a miscarriage of justice is now no longer good enough. It has to say, well, we think there may have been a miscarriage of justice, but nevertheless, for the need for finality and certainty, we're not going to refer it to the High Court. But say they did pass that test, and they did refer it to the High Court. Previously, the High Court had to accept a referral. No ifs, no buts. But that changed in this emergency legislation. Because the High Court, in determining whether or not it's in the interest of justice that any appeal arising from the reference should proceed, the High Court must have regard to the need for finality and certainty in the determination of criminal proceedings. So we have the first hurdle at Criminal Cases Review saying, well, finality and certainty, we'll pass that test. They pass it to the High Court, and it sets that test again. The very High Court which heard the case in the first place. Now, I have to say, to me, that is not a just system. If I may also say, it's no assurance to go through the Criminal Cases Review Commission. Many people apply and very few get to the stage of a referral. But referrals can be very successful. And again, if I look at the Criminal Cases Review Commission's success rate, for instance, they made 10 referrals in 2010 on sentencing. 4 in 2010. 2 were successful and 2 are still being determined. And when it was for sentence alone, which would obviously say if your conviction is gone, you've got no sentence, of them there were 4 referrals. 2 were successful, 1 failed, and 1 is still being determined. So they're not making referrals willy-nilly, and they're being quite successful. Now, my concern is that that route will no longer be open not just to Megrahi, because it's my understanding that the SCCRC can, in certain circumstances, make a referral again, even though an appeal has been abandoned. And this is very strange circumstances. And there are so many unanswered questions for everybody. Whether it's people who believe he's guilty, people who believe he's innocent, victims' families, there's no line drawn in the sand on this. So that has now been blocked as a route. Now, I'll give the Cabinet Secretary his due. When I raised this, he said that he would review this matter. You know, he's got a panel of judges reviewing how this legislates. He will review how this operates. Well, I have taken the time to say this is that the government are saying, first of all, he closed it down himself. Well, we know why. Secondly, they're saying the criminal justice system has a route. Well, I think the SCCRC has been neutered in many respects now. So if I may say to the committee, I would wish you to continue to pursue the inquiry route, not to close this down. If I may suggest, convener, that you also confirm with the SCCRC if it can reopen an abandoned appeal on its own. I'd also like to know what views they had, that the SCCRC had on this limiting of their powers, if any, and when that review panel will report on the functioning of this legislation. Now, you may feel this is not pertinent to the petition. I feel it really is, because if you don't know that bit, you don't know why people are pressing so hard for public inquiry, because they have concerns that everything else is being shut down. Indeed, the statement of reasons is not being published because there's subordinate legislation that says if any party, third party, is given evidence or even indirectly given evidence and they don't want this published, it won't be published. So pretty well we're not going to get anything. So it does seem this is the final court. And lastly, on the mace, it says we'll have justice, integrity and compassion. Well, no wonder they call themselves Justice for Megrahi, because frankly, at the moment, there hasn't been justice for anybody in this particular case.
Okay, thank you. Yes, Bill.
Yes, I am going to suggest in a very... I'm going to delimit the way, is that the right thing to say, that I'm suggesting that we, to colleagues, that we continue, because I was going to say that actually this committee had no further locus, because we have been told that the Scottish Government has again stated it has no plans to initiate an inquiry on this issue and has clarified why it does not consider an inquiry to be necessary, and that has been referred to by Christine Graham in the letter that we received from the Scottish Government. And again, I think we have to realise that this is simply a public petitions committee, and we cannot, we certainly cannot make a judgment in that kind of formal way. However, I do think it would be, I'm not sure how colleagues feel on this, but I do think it would be at least worthwhile if we did 2 things. Firstly, to, as Christine Graham suggests, write to the Cabinet Secretary and ask whether he will review the application of the emergency legislation as he has promised, and if that is his intention, and I don't doubt it because he told Christine Graham, a member of this Parliament, that that was his intention, then when will his review take place, and when will his decision in that respect be known and made known, and how will it be made known? And secondly, and again this is simply a point that brought up by Christine Graham, can the SCCRC open and abandon appeal? Now, these are two questions to which the first, hopefully we know the answer or part of the answer. Second, we really don't. And I think on those two specified points, specific points rather, we can continue. But I have to say this, that once we ask those questions, unless someone can be ingenious enough to come up with other ways in which we could legitimately continue this as a public petitions committee, I mean, the arguments will continue, the controversy will continue, then if there is no further ingenious way of proceeding in terms of public petitions, then we will have to close. But I do think it's worthwhile in those fairly narrow questions that Christine Graham suggested that we continue, and I suggest that to colleagues.
Matthew, then Nigel.
Yeah, I'll support that, and I think, you know, particularly in the summary there, Bill's final points, that, you know, I think we have to go back and ask these couple of further points for clarification, and if we don't get anywhere, then we, you know, it's difficult to see where the Petitions Committee could go. Like the petitioners, I think, you know, just from reading their response to the letter from the government, and the paragraph 3 with, for the quote about the Inquiries Act 2005, I just find the reasoning there for saying that they couldn't hold or couldn't conduct a public inquiry is just so weak. And I'll not use the words I think that the petitioners have used in their written submission to us. You know, it's just it's an excuse and it's hiding behind. It seems that, you know, every time the Scottish Government touch this Megrahi case, they do something wrong and the goalposts change. So I do support my colleague Bill Butler's suggestions. I think we should do that and see if we can get that back before the next committee. Again, I have to make comment to in the length of time that it took to respond to the Megrahi inquiry letter to them. I know that you, convener, have written to the First Minister regarding this issue, but I'm sure there must be a whole load of civil servants who are very familiar with every detail of the Megrahi case, and we could, you know, they could put their hand to writing this response very, very quickly. So if we can, you know, if I don't know whether it's the committee clerk or you yourself, convener, who writes the further letter to the government, but if we can ask that we can have a quick response, because we do want to deal with this within this term of the committee.
Okay, thank you. Nigel, then Robin.
Thank you, convener. Can I say that I think once you've got a response from the government, there's little prospect we're going to get a different one. However, banging on the door will do no harm. It does, however, occur to me that we haven't yet specifically, as far as I recall, written to the Lord Advocate. And I'm just wondering whether the Lord Advocate, as the senior and independent law officer, actually has, perhaps somewhere in the mists of time, residual powers to investigate this, that and the other. It may be clutching at straws, but I think it's one sack of straws we need to consider. I wonder whether the law officers do have some residual power to investigate, reconsider a case under these kind of circumstances. I won't even define what the circumstances are. I think we should just be asking the Lord Advocate to have a think about what she might be able to do.
Thank you, convener. I think, considering that the petition was extremely limited, it said to urge the Scottish Government to open an independent inquiry, and we've twice been told, at least twice, that the Government has no intention of so doing, that we would have every right to close the Commission today. But I've listened to Christine Graham's arguments, and I feel it's, for the sake of the petitioners, it's worth writing to the SCRCC to get their opinions and then forwarding those to the government for the government's response. given it is 7 weeks to dissolution, I would consider it to be extremely unlikely that that process will be completed before dissolution. And so we have to think of this as part of our legacy to the next Parliament's Petitions Committee.
Okay, it's agreed that this petition will be continued. Right, in those terms. Thank you very much. Thank you very much for your attendance today.